I mean, Good morning. It is 8:31 on August the 6th. This is the regularly scheduled hearing by affidavit docket. We have about 41 cases on the docket today. Okay, we're going to begin with cases that will be heard by myself and technical examiner Patricio Sanchez. Mr. Sanchez, are you with us?
Yes, sir, I am, Mr. Examiner.
Okay, thank you, Mr. Sanchez. I hope you're feeling better today.
I am. Thank you for asking.
All right. Starting out with case number 1, this is ConocoPhillips 26229. Entries, please.
Mr. Examiner, good morning. Dana Hardy with Hardy McLean on behalf of ConocoPhillips, and there are no other parties in this case.
Good morning, Ms. Hardy. Go ahead.
Thank you. In this case, ConocoPhillips is seeking to pool uncommitted interest in the Bone Spring Formation underlying a 1,600-acre non-standard horizontal spacing unit comprised of the south half of Section 23 and all of Sections 26 and 35, Township 23 South, Range 30 East in Eddy County, and they propose to dedicate the unit to the Fury Road FedCom wells. Exhibits were submitted last week and include the land testimony and standard exhibits of Ashley St. Pierre, who has previously testified before the division and been recognized as an expert in petroleum land matters. We've also provided the geology testimony and exhibits of Rachel Shanks, who has not previously testified before the division. We did provide her resume, and if there are questions for her, we'll need to have her admitted as an expert before the division. Our notice testimony and exhibits show that notice was timely sent on June 15th and 18th, and also July 1st, and that we timely published on June 17th. So with that, I ask that the exhibits be admitted and that the case be taken under advisement.
Thank you. Admitted all exhibits into evidence without exception. Mr. Sanchez, I believe there's a fix on the CPAC and the C102?
Yes, sir, Mr. Examiner. This, I guess, would be for Mrs. St. Pierre. It would be on page 3 of 80 of the CPAC, and also it's regarding the pools. So there are actually 3 pools that this project area crosses, and so on the CPAC page 3 of 80, it's going to be the south half of section 23 49er Ridge Bone Spring Code 24720. Section 26 will be 49er Bone Spring West Pool Code 96526. Section 35 will be WC-015G-0633036D Bone Spring Pool Code 97944. No worries, I will email this table and then the other ones to the council so they can distribute that to their affected parties, and that way we can hopefully get this stuff in by the end of the day, Mr. Examiner, if that meets your approval.
Sure. Ms. Hardy, will you pull up page 3 and share your screen?
Sure.
That's it.
All right. So, Ms. Hardy, I know he's going to email you the information you just wrote down, but do you understand what he needs?
I do. It sounds like we just need to add the additional pools here to the checklist.
And Mr. Examiner, if it so please you, I can go through the other pages for the particular 102s and we can list those off. Of course, they'll be in the notes too, sir.
Hold on, thank you, Ms. Sanchez. Hold on a second. Do you need that, Ms. Hardy?
So, I don't think so.
Okay. All right.
I think I understand.
Okay, sounds good. And you'll be able to get this in today?
Yes.
All right. We'll leave the record open till 5 p.m. and then we'll take the case under advisement if you get this information corrected. Can you attach a cover letter to and explain what you're changing?
Yes.
All right, fantastic. Mr. Sanchez, anything else, or can we go off the record in this case?
We can proceed and go off the record, sir.
All right, thank you.
Thank you.
Thank you, Ms. Hardy. Let's call the second case on our docket. This is Permian Resource Operating LLC 26235.
Yes, Jackie McLean on behalf of Permian Resources, and we have consolidated case numbers 26235, 26236, and 26237.
Okay, thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Mewburn Oil Company, and we're just entering an appearance to preserve rights.
Thank you.
And that's the only other party. Thank
Right
you.
ahead, Ms. McLean.
Thank you. In these companion cases, Permian Resources is seeking to pull all uncommitted interest in the Bone Spring and Wolf Camp formations in sections 27 and 28, Township 21 South, Range 27 East in Eddy County. And these units will be dedicated to the Uncle June FedCom wells. And in case numbers 26239 and 26235 and 26236, we're seeking approval of a non-standard spacing unit. Exhibits were timely submitted last week and include the land testimony and exhibits of Daniel Curry, who has previously testified before the division and has been recognized an expert in petroleum land matters. And we also include the geology testimony exhibits from Charles Ward. He has not previously testified before the division, so if there are questions, we would seek to have him admitted as an expert in petroleum geology matters. We've also included notice testimony along with copies of the notice letters, which were timely sent to all interested parties, along with an affidavit of publication. And with that, I ask that the exhibits be admitted for case numbers 26235, 26236, and 26237, and that the cases be taken under advisement.
Admitted without exception, and I believe case 26235 we can take under advisement now. I believe there are some pool code fixes that we require to take the others. So, Mr. Sanchez, is that correct?
That is correct, Mr. Examiner. So at your pleasure, case 26236, we'll need to fix that pool to Carlsbad East Bone Spring Oil, pool code 96144. And the affected page on the CPAC is page 3 of 81. Exhibit A on the C102s, it's going to be page 12 of 81. But again, I'm going to email this to you so you'll have it, but just for the record, so it's recorded on this video. And then that's it on that one. And proceeding to 26237, again, we need to fix that pool to Carlsbad East Bone Spring Oil, pool code 96144, and it'll be page 3 of 71, and C102 on page 12 of 71.
Ms.
And that's
Sanchez,
it, Mr.
Ms. Sanchez, do you have Ms. McLean and Ms. Hardy's email?
Yes, sir, I do.
All right, fantastic. So, Ms. McLean, you can get that in by 5 o'clock in both cases with the cover letter?
Yes, for sure.
Fantastic. We'll leave the record open until 5 p.m. today, and then we'll take the cases under advisement.
Thank you.
If there's nothing further, Mrs. Sanchez will be in recess on those two cases.
Nothing further, sir.
All right, thank you. Let's move on to Permian Resource Operating Case 26238.
Yes, Jackie McLean again on behalf of Permian Resources, and we have consolidated case numbers 26238, 26239, and 26240.
Thank you, Ms. McLean.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Mewburn Oil Company. Again, we're just entering an appearance and preserving rights. I just wanted to, on the record, if Ms. McLean can confirm for the one case that Mewburn that we discussed this morning, which was case 26240, that Mewburn is just an offset and not an interest owner, and that's why they received the notice. Thank you.
Ms. McLean?
Yes, we are not pulling them in that case.
Perfect, thank you. Go right ahead.
Good morning, Mr. Examiner. This is Jordan Kessler on behalf of EOG entering an appearance, just monitoring today.
Thank you, Ms. Kessler.
Thank you. In these cases, Permian Resources is seeking to pool all uncommitted interest in the Bone Spring and Wolf Camp formations in sections 33 and 34, Township 21 South, Range 27 East in Eddy County. And these units will be dedicated to the Gabagool FedCom wells. Exhibits were timely submitted last week and include land testimony and corresponding exhibits of Daniel Curry, who has previously testified before the division and has been recognized an expert in petroleum land matters. We also have geology testimony and exhibits from Charles Ward. Again, if we have questions for him, we'd ask to admit him as an expert in petroleum geology matters. And finally, notice testimony along with copies of the notice letter and affidavit of publication. And I ask that the exhibits be admitted for case numbers 26238, 26239, and 26240, and the cases be taken under advisement.
Admitted without exception. We have the same situation as the last three cases. Case 26238 is taken under advisement at this time, but we will need pool fixes for the other two cases. Go right ahead, Mr. Sanchez.
Yes, sir. 26239, the pool needs to be fixed to Carlsbad East Bone Spring Oil, pool code 96144, the CPAC page 4 of 143, and then exhibit A3 on the C102s, page 17 of 143 and page 19 of 143. On the case 26240, again, the pool needs to be fixed to Carlsbad East Bone Spring Oil, pool code 96144. Fixed pools on the CPAC page 4 of 132. Exhibit A, 3 C102s, page 17 of 132 and page 19 of 132. And that's it, Mr. Examiner.
Thank you, Mrs. Sanchez. Ms. McLean, 5 p.m.
Yes, that works for us.
with cover letter?
Yes, we will do
Perfect.
that.
We will leave the record open and take the cases under advisement at that time.
Thank you.
All right, thank you. We're off the record in those cases. Let's move on to case number 8 on the docket. This is Coterra Energy, 26249.
Good morning, everyone. Dina Bennett on behalf of Coterra Energy Operating, and there are no other parties that have entered an appearance in
Good
this
morning,
case.
Ms. Bennett. Go right ahead.
Thank you. This case was originally heard on July 9th, and at the July 9th hearing, I noted that we had inadvertently not sent out notice letters to the non-standard unit offsets. And so we are back today to cure that notice, and included in the revised or amended exhibit packet is Exhibit D, which includes my self-affirmed declaration showing that notice was timely sent to the non-standard unit offsets. And it includes a sample notice letter, mailing list, certified tracking information, and an affidavit of publication showing that notice was timely published on July 15th. So with that, I would ask that the exhibits in case number 26249 be admitted into the record and the case be taken under advisement.
And these are amended exhibits, is that what you said?
They are.
Okay, very good. Those are admitted without exception. The case is taken under advisement. Thank you.
Thank you.
Let's move on now to case number... Ms. Bennett, that case that I just called, that we just heard today, there was a companion case, 26250, and I believe that's closed.
That's correct. That case did not need to be continued for notice.
Perfect.
Thank you.
Okay, let's move on now to case number 9 on the docket. This is the last case Mr. Sanchez is a technical examiner for. It is PBEX Operations 26285.
Dana Hardy on behalf of PBEX Operations.
Thank you. Is there anyone else in this case?
Yes. Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of MRC Permian Company, and we are just preserving rights.
Thank you, Ms. Vance.
And Mr. Examiner, Carrie Hatley, representing Marathon Oil Permian, monitoring only.
Thank you, Ms. Hatley.
Thank you.
Go right ahead.
Thank you. In this case, PBEX seeks to pull uncommitted interest in the third Bone Spring sand underlying a 640-acre non-standard horizontal spacing unit comprised of the east half of sections 24 and 25, Township 18 South, Range 32 East in Lee County, and will dedicate the unit to the LTK 2425 FedCom wells. We submitted our exhibits last week and included the standard exhibits and land testimony of Ruth Pelzel, who has previously testified before the division and been recognized as an expert in petroleum land matters. We also submitted the geology testimony and exhibits of Kristen Bradshaw, who has not previously testified before the division as an expert in geology, and we provided his CV in case there are questions for him. We did provide amended exhibits on Monday, and that was to update the pooled parties list because there were several parties who signed on to agreements. We provided our notice testimony and exhibits, which show that we timely sent notice on June 11th and timely published on June 14th of 2026. So with that, I ask that the exhibits be admitted and that the case be taken under advisement.
Admitted without exception. Mr. Sanchez, did you have a chance to see the amended exhibits?
Yes, I did, Mr.
right.
Examiner, and I did note that they had an NSP prior non-standard location package approved for this well administratively, and I checked that, and that's fine too.
All right, thank you, Mrs. Sanchez. That's thorough. This case is taken under advisement. Thank you, Ms. Hardy.
Thank
And
you.
thank you, Mrs. Sanchez.
Thank you, Mr. Examiner.
All right, the rest of these cases will be heard by Technical Examiner Dean McClure. I see him on the screen. Good morning, Mr. McClure. We're going to start with case number 10. This is an amendment case, Permian Resources operating, 26054 and 55. Entry, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Permian Resources.
And I believe you're continuing these cases?
Yes, we're continuing these cases. I talked with Mr. McClure yesterday. This is an instance where we're working through doing the administrative submission for a first-time extension. There are a lot of notice parties. We have about 800 plus notice parties. And so Mr. McClure had some feedback, and we're working through that just to provide the division additional information. But we asked to continue the case, and I'll be updating Mr. McClure on when we'll do the administrative submission. So
when are you continuing these cases to?
To the 9/3 docket, but we are hopeful that by then we're going to dismiss and open that up. We'll dismiss the hearing cases by submitting the administrative and getting those approved through the administrative process.
And I'd like to talk about that. I was going to wait until case number 17 through 21 on our docket.
I would love to talk about
to talk about this. And I'm really opening up this discussion to anyone who wants to chime in about the process here, because I feel like we need to work out a better process for this so we don't clog our docket. We have 7 cases here that we don't even need on this docket, and that bumped 7 cases and delayed them a whole month. There's got to be a better way to do this, but I'll start with you, Ms. Vance, because they are your cases, exactly. It's my understanding that you have to file something before the order expires to toll the time until you get an approval or a denial based on the good cause or whatever other words are now in the ordering paragraph. I don't even know if it requires good cause anymore for certain types of extensions. Okay, so that being said, what is the current process you're using, and do you have a suggestion for a better process?
I can answer both of those.
Good.
So on the first point or first part there, what we are doing is we are filing an application to toll the expiration date. And using that as a backup as we're working through the administrative process, and then just working with Mr. McClure, because he's been reviewing all of these, on continuing the cases and keeping them live on the docket so we don't, the orders don't expire. So again, we're filing that application for a hearing while also going through the administrative process. My suggestion, and I'm glad that you asked because I was going to bring this up, is if it were possible to have a special docket just for filing applications for first-time extensions. That way applicants can just file as they're working through this process. I've talked with Mr. McClure. He said, they're working through their process on their end. So it's both sides that are working through it. So if there was a special docket that we could just file these first-time extensions to and just continue to toll using that date, that would be great. That way we are not clogging up the regular docket.
So before I open this up to other councils, because I do want to hear from everyone else who has an opinion about this. What I was wondering is, it seems like council thinks an application for a hearing is the only type of application that would toll the time. Why wouldn't an administrative application toll the time?
I mean, other than the fact that we've not gotten instruction from the division that that will satisfy tolling, I mean, that's the only reason why not, because we've been using this process of filing an application to toll. And so that's what we've been going with. But if we got guidance from the division that we could toll by filing something else, then we would do that.
So legally, and I'm asking for your legal opinion as well, is there a reason why you think an administrative application for an extension of time would not suffice to toll the time?
Not from my perspective. Again, I'm just going off a prior precedent of what's been done by the division previously, and it required going to hearing or filing the application, and that would toll. So if the division provides instruction that filing some sort of administrative application will satisfy tolling the expiration date, I don't want to speak for all of my colleagues, but, from my perspective, I would be fine with that.
Because in my mind, if you did that and then you waited your 20 days or whatever it is for objections, because I think that's the period for objections, right? 20 days?
That's correct.
And if no objections came in, you could then notify the division, no objections have been received. Within that period of time, please process or file an affidavit, a self-affirmed statement saying.
So just so I'm getting this right, we would file a notice in the original case file informing the division that we are seeking approval of a 1-year extension, and then initiate the notice process. Once the notice process completed and there was no objection, we would just file the affidavit at that point.
So I said it a little differently than you did. What I was thinking was you'd file your administrative application with the division. If you file a notice into the case file, that also works at the same time as the application for the administrative approval of the extension of time. Then you wait the 20 days. Once the 20 days are over, if there's no objections, then you file a notice with the division saying the period is up, no objections, please process the administrative application. If there is an objection, then you go ahead and file your application for a hearing at that point. Does that make any sense?
It does. I'm just wondering about the notice piece of it.
Right.
That we would file our applications, because I don't know how other people are filing either, and I'm just only thinking from our perspective, is that we prepare an application and we send that out with a list of the notice parties. And then when we're filing the actual application, we're including the tracking report. So, I mean, I guess we could send out the notice, get our tracking report, and just at that point to, what you're saying, file the application and then wait our 20 days and then file an affidavit. I guess my question would be, because the attorneys were sending out the notice, is it satisfactory that we are providing that affidavit?
I would think so.
Okay.
I mean, you already provide an affidavit in tab D of just about every application you file. We rely on your candid affirmation.
Yeah.
Ms. Bennett?
Thank you. So the division has sent out guidance on how we should approach these applications. And that's how I know I've been doing it. I think that's how Ms. Vance has been doing it. I'm not sure how Ms. McLean and Ms. Hardy have been doing it. And I don't really see a reason to deviate from the process that the division has instructed us to use on the backside. But I do agree that if there is guidance from the division that the filing of the administrative application tolls the order's expiration, that's all we need at this point. I will say that I did have 2 cases set for today's docket to hold, but I continued them. So, I mean, if there's no reason why we can't just automatically continue them to the next docket to keep the order alive. We used to continue cases all the time that kept an order alive. So I'm not throwing any shade or anything. I'm just saying that there's another mechanism, which is to just voluntarily continue the cases to the next docket.
Okay, that's great. But that doesn't answer my question, so let me go back to ask the question directly. So do you see any reason why an administrative application would not toll the time for an extension of time?
I do not.
You do not?
No.
Okay. And do you think that's a workable solution to try to keep as many of these EOTs off the hearing docket to basically not file anything? What I'm really saying is you have an administrative track and then you have the hearing track. You don't really need the hearing track unless you have an objection, is the way I see it.
Right.
Do you agree with that?
Yes, 100%.
Okay. Then but it confused me because you said we already have guidance, why don't we just stick with that? And I don't know what that guidance was, but don't confuse the issue right now.
Okay.
I'm just trying to find a better process.
Right. And I think that if the division were to tell us affirmatively, because I know we've all had conversations with the division off the record about whether the filing of an administrative application tolls the hearing. And I think the answer to date has been somewhat ambiguous. And so if we were to get affirmative guidance to that, that would resolve this issue. The only additional information that would be helpful in that guidance is that if we file an administrative application and it gets objected to, that also tolls the expiration of the order, because we could file an administrative application within a month of the order being expired and then get an objection and then file the actual application, but we may not be able to file the actual application until the order has expired.
But if the administrative application tolls the time, why would you need something else to toll the time?
Because if it's objected to and we have to file a hearing application, then that would be filed after the time the order was issued. So all I'm asking for is just confirmation that is accurate.
You could attach the original administrative application to your hearing application and say, here was the timely filed administrative application that told the time. Now we need a hearing, but that would be, anyway.
That sounds great.
Thank you, Ms. Bennett. Ms. McLean.
We haven't been double filing. We've been filing with enough time to just get the order. The first time I did that was actually Tuesday because I think you were copied on, our administrative application was rejected because we didn't notice everyone correctly. So we redid notice Monday. I filed Tuesday. I'm hoping to dismiss it out because it still has plenty of time before the next docket. So it hasn't actually been an issue on our end.
Well, okay, but I'm still looking to get consensus on. I'm still looking to get consensus on a new procedure. So if you've heard the discussion so far, what are your thoughts?
I think that it would be fine to just file the administrative application and toll it. Mr. McClure emailed that it wouldn't, but I don't know if that, I don't see why it wouldn't be the same as with the hearing. So I guess I'm fine with, I haven't really thought about it since we haven't had that issue come up, but I think there's nothing precluding it from tolling it in the roll.
Right, exactly. And there's nothing in the order that requires an application for a hearing versus an application for an administrative approval. There's nothing discriminating between the two, right?
Correct.
Okay. Ms. Hardy, do you have anything further? No.
No, I agree.
Okay. Ms. Hatley? No. Okay. Ms. Pena? No. All right. I can't see who's in the back. I don't have my glasses on.
Hey there.
Oh, hi.
The hearing I came to sort of
Yeah, sure. The hearing has been continued. There's no hearing.
Durham resources, it's been August 20th.
What resources?
In Durham.
Freya, do you know anything about that?
It was objected to, and so it's on the August 20th docket.
Oh, it's time for a status conference.
Correct.
Are you the attorney for?
No,
You're just here to observe. Okay, great. Well, you'll have something else to observe. This is not as exciting as that, but we'll do our best. Mr. McClure, you've been listening. Do you have any follow-up questions?
Mr. Hearing Examiner, yeah, I guess the only question I would have that it'd be good maybe to get some input from the attorneys on is in the instance that a admin application were to be rejected, what is the thought process there in regards to keeping the case open? And would it be a better thought process that the division would need to, like, quote unquote, return an admin if something needs changed versus rejection?
So, is that something that happens on a regular basis where we reject those administrative applications?
We have had significant issues with the notice being followed through.
What you were saying, Ms. McLean.
Yes, because now I know what Mr. McClure wants, because before I was just including, like, if we didn't send notice out to everyone that was part of the original one, I just put a little sentence in my letter, but I think he wants an affidavit from the landman that says that title has changed. So we are going to be either sending it out to everyone or including an affidavit.
I mean, Mr. McClure, I mean, isn't the whole purpose of the application to alert the division that the operator intends to request or is requesting the 1-year extension? And even if it was defective for some reason, wouldn't the division be able to hold on to it and alert the operator, say, hey, it's it's not complete, it's not something or other? It seems to me that that's a semantic thing. I don't know. Ms. Vance?
Yes, I mean, I guess it depends on what the rejection is. If it's rejection based off of, can you do these corrections? It seems to me, and the process has been just working with Mr. McClure to make those corrections. But that's really been the only basis I've seen so far. So if he's willing to keep the case or the application alive while we fix it, then I don't see an issue.
Ms. Bennett?
Same.
Right, I thought so. And Ms. Hardy and Ms. McLean, same, I thought so. So, Mr. McClure, I think it really depends on how the division treats a defective application, but I think that's something we can talk about offline at our weekly meeting.
I'm in agreement, Mr. Hearing Examiner.
All right, thank you, Mr. McLean. Mr. McClure, sorry. Sometimes I get those two mixed up. All right, let's go on. Okay, so we continue, Ms. Vance, motion to continue. So, Freya, would you approve the continuance to the September 3rd docket for case 10 and 11 on our docket?
Yes.
All right, thank you. All right, we're off the record in those cases, and thanks for the discussion. Okay, let's go on to 26057 Matador Production, number 12.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, MRC Permian Company. Excuse me.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating, Concho Oil and Gas, and Mongoose Minerals, monitoring only.
Thank you.
Good morning, Mr. Hearing Examiner Yaritza Pena with Hardy McLean on behalf of Permian Resources Operating. We're just monitoring as well.
Who is the party that objected, that withdrew the objection, Ms. Vance?
That's a great question. I do not know.
I can help Ms. Vance.
Good,
It was
good.
Permian Resources, and we withdrew our objection.
You did. Very
Yes.
good. Thank you. Go right ahead, Ms. Vance.
Thank you. So in case number 26057, MRC seeks to pool a 478.67 acre horizontal spacing unit, and that is in the north half of sections 16 and 17, and the north half equivalent of irregular section 18, and that's all in Township 21 South, Range 31 East, Eddy County, New Mexico, and this involves the Bone Spring Formation. And MRC seeks to initially dedicate the spacing unit to the Corby Federal Com 101H, 150H, 111H, and 145H. In our hearing packet, we have included our landman statement and geology statement. Our landman is Clay Wooten, and our geologist is Joshua Burris, both of whom have previously testified before the division, and their credentials have been accepted as a matter of record. And along with their statements, we've included the required sub-exhibits for land and geology respectively. After that, we've got a self-affirmed statement of notice. I think it might be my colleagues, Mr. Rinkin. And that notice was timely. It was mailed out on April 17th, 2026. And along with that, we've got our notice of publication affidavit, which was timely published on April 16th, 2026. I will note that there is one interest owner, Michael Grace. He's on the pooling exhibit, but when I was going through and checking our tracking report, I noticed he didn't show up. The reason for that is because his mail went to Costa Rica. He's living the high life in Costa Rica. So I will file a revised hearing packet that includes a copy of that international mailing that we did. And I can get that done by 5 o'clock today. And you will see, I believe my colleague, Mr. Rankin, again, filed a revised hearing packet. These have been pushed out a couple of times, I think because of capacity on the hearing dockets. But there is a cover page that outlines any of the updates that have been done. And unless there are any questions, I would ask that this case be taken under, that the exhibits and sub-exhibits be admitted into the record and that the case be taken under advisement at this time.
Thank you, Ms. Vance. Admitted without exception. Mr. McClure, who do you have questions for?
I'll have questions for the landman, but could Ms. Vance, could you say that one more time about the notice? I apologize.
Sure. Sure. There is an interest owner, and I can just show you really quick if that is helpful. His name is Michael Grace. And I noticed that the tracking report did not show him on there. Let me just go like this. I don't know if you can see. There we go. This is Mr. Michael Grace right here, and Mr. Michael Grace lives in Costa Rica, but I was able to get a copy of the postal delivery or mailing to his international address. He's not reflected on the mailing report that we included, so I can file a revised hearing packet that includes evidence that we sent him the notice.
And was notice sent to him prior to?
Yes.
I guess I don't have it right in front of me.
It was sent out
17th. It looks like prior to that.
It was sent along with all of the other notice on April 17th. Again, it just wasn't included in our typical mailing report because it was an international mailing.
Okay, so and precisely.
And this is all domestic. So this just shows domestic deliveries.
So the proposed amendment that you would make would be to either include an additional table or just to add Michael Grace to the current table with that international tracking number.
I will just add it as a additional supplement to the tracking report.
Okay, and that additional supplement would essentially just be a table like what you normally would have, except to just have an international tracking number instead. Is that correct?
It'll be the actual, a copy of the postage, and it'll have a copy of that international, or it'll have a copy of the tracking number on there.
Okay, thank you, Ms. Vance. Thank you, Mr. Hearing Examiner. I only have questions for the landman now, I believe.
Would you call your landman?
Yes, Mr. Clay Wooten.
Ms. Vance, if you don't see him, we can come back to this case as soon as you get word that he's on.
Can y'all hear me?
There he is.
Yes, would you turn your video on, please?
Yes. So is it working? It should be on.
I see you. Would you raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes.
Thank you. Would you spell your name?
Clay Wooten, ClayWooten.
All right, thank you. And you have been admitted as an expert as a landman by this division?
Yes, sir.
Thank you. Go right ahead, Mr. McClure.
Thank you, Mr. Hearing Examiner. Mr. Wooten, I'm looking at your commitment table on page 49 of 61. Looks like Ms. Vance has it on the screen.
Yes.
Mr. Wooten, do you see down there where it says Dave Percy and Associates Incorporated, and they're listed as a working interest owner?
Yes. Yes. So that we got a title opinion back, and he doesn't own any interest in there. That went to PBACs.
Okay, so then this person should not be listed in the commitment table. Is that correct?
Yes, that's correct.
Okay, and that person's interest is a part of what PBEX owns. Is that also correct?
Yes,
Or
that's correct.
what used to be his interest?
Yes.
Okay. So I guess if I were to ask you to remove Dave Percy and Associates Incorporated from the commitment table, do you understand what I'd be asking for?
Yes, sir.
And is that something you'd be able to accomplish by end of business day today?
Yes, sir. We can knock that out pretty quick.
Okay, so the amended exhibit that you would be submitting, or I guess Ms. Vance would be submitting, would it be accurate to say that essentially it's going to be this exact same table except for the removal of Dave Percy and Associates Incorporated?
Yes.
Okay. Thank you, Mr. Wooten. Thank you, Mr. Hearing Examiner. I don't have any further questions.
Okay, so do we need this case to come back for further review?
Oh, Mr. Hearing Examiner, I think if they can get it to us by 5 o'clock, I believe we have an accurate portrayal of what it's going to end up being. So I think we should be fine.
Okay, thank you, Mr. McClure. Ms. Vance,
We can get it done.
with cover letter?
Yes.
Perfect, thank you. All right, we're off the record in that case. Let's move on to Ms. Vance. There was a case that was joined with that case, 26058. We have that set for a contested hearing September 3rd.
That sounds correct.
All right, very good. Let's move on to case number 13 on our docket. This is Mewburn Oil, 26158. And let's see, yes, it is joined with 26162. Entries, please.
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Mewburn, and there are no other parties.
Please proceed.
Thank you. In these two cases, Mewburn seeks to pool uncommitted interest in the Bone Spring Formation in sections 7 and 12, Township 20 South, Range 29 East in Eddy County, and will dedicate the unit to the Jericho Fedcom wells. Our exhibits include the land testimony and standard exhibits of Josh Anderson, who has previously testified as an expert in petroleum land matters before the division, and the geology testimony and exhibits of Charlie Crosby, who has previously testified as an expert in petroleum geology matters. Our notice testimony and exhibits show that notice was timely sent on July 13th, 2026, and that we timely published on July 22nd. With that, I would ask the exhibits be admitted and that the cases be taken under advisement.
Admitted without exception. Mr. McClure, who do you have questions for?
The landman, Mr. Hearing Examiner.
Ms. Hardy?
Mr. Anderson should be on.
Yep.
Please.
I'm here.
Mr. Anderson, I'm looking
Hold
at
on,
the...
Mr. McClure, I haven't
Oh,
seen
I
him yet.
apologize, Mr. Hearing Examiner. Yeah, we haven't.
That's okay. You're just raring to go. All right, Mr. Anderson, please raise your right hand. Do you swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Thank you. Would you spell your name, please?
Josh Anderson, Joshanderson.
There might be something wrong with your microphone, Mr. Anderson. We're not picking you up. Try again.
Josh Anderson,
Better.
Joshanderson.
And have you been admitted as an expert in petroleum land matters by this division?
Yes, sir.
Thank you. Go right ahead, Mr. McClure.
Thank you, Mr. Hearing Examiner. Mr. Anderson, I'm looking at there's three assorted lists of ownership within the exhibit packet, and they don't seem to match. and I'm trying to figure out like which one is correct. So for instance, like I'm looking at your page 13, and there's like a number of persons listed there for tracks.
Yes. Yeah, those are all the parties that own in those specific tracks.
Okay, but shouldn't the summation of those be equal to the list that's on page 15?
They are. The leasehold percentage that is next to Mewburn's name includes all those parties that are that have signed a JOA and are committed, and that we are not pooling for those specific tracks. And you can find that on page 21. It lists everybody.
So then, Mr. Anderson, is it accurate to say the commitment table is a full listing of every person?
Yes, sir.
Is there anywhere in your exhibit packet that shows the unit ownership of each of these people, or the ownership of each of these persons within the overall unit?
No, not individually. Just a summation.
And does this table also match the ownership list that you have on page 13, which is the track breakout?
No, because not everybody that is committed and signed the JOA owns in those specific tracks that are listed on page 13.
Could you elaborate on that a little bit more, I guess?
This is a larger unit that includes all of Section 7 and the east half of Section 12. Some of those parties on page 21 own in the south half of Section 7 or 12, for instance. So on page 13, the parties listed only own in these specific tracks that we're pooling today.
Okay, so there's persons on your commitment table that are not going to be a part of this unit. Is that correct?
They are a part of the unit because they've signed the JOA, so they've been spread contractually into it, but they don't have operating rights per se in these specific tracks.
So then is Mewborn giving a percentage of their ownership in these tracks to the JOA signers that don't own an interest here? I don't understand where the money from, I'm not understand how the production from this unit, I guess, is being contributed to persons that don't own an interest in the unit. I guess that's what I'm trying to understand, and how that percentage is shown anywhere in your exhibit.
Not real sure how to answer that one, besides saying that once you sign a JOA that covers a larger unit, you're spread contractually into this unit, but you don't have operating rights in it. And the two parties we've listed to pool today own operating rights in this specific tract, and have not signed a JOA, or else we would not have listed them.
So essentially, you're treating this area that's covered under a joint operating agreement as if it's like a participating area within a federal exploratory unit. A similar concept. Is that accurate to say?
Yeah, I guess you could probably say that.
Is that a common practice to your understanding?
As far as I am concerned, yes.
Would it not be more accurate to say that typically the compulsory pooling, the units that get formed after a compulsory pooling order are overlapping with that rather than allocating production to that JOA?
I'm going to have to defer to my attorney on that one. I don't understand.
I guess, is there anywhere in this exhibit that these interest owners that don't own in that JOA that you're asking the division to force pool, is there anywhere here where they can see how much of their production is going to go to the signers of a JOA that includes outside tracks?
I mean, on page 15, it lists what their interest is, what the pool party's interest is in those specific tracks and as a total for this proration unit.
So then you're saying that a part of this Mewborn et al., a part of that production is going to owners that do not own an interest in this unit. Is that correct?
They don't own operating rights in this unit, yes, but they have contractual interest.
Do you include anywhere within your exhibits that displays the area that's covered by this JOA that you're including here, I guess?
You could look on the well proposals on page 16 that were sent, and on that letter, it discusses the unit. Says the entire 923.88 acre unit of the caption section 7 and east half of 12 will be dedicated to these wells.
Are you asking the division to force pool the entirety of section 7 and east half of section 12 into a singular unit?
No. Just for this specific case, we're just force pooling the north half of section 7 and the north half northeast of section 12.
And is it the entirety of section 7 and east half of section 12 is the area that you're including in this JLA that you're spreading throughout all of these individual compulsory pooling cases?
No, there's actually the existing JOA covers more than just this, but these wells proration units are smaller. So the existing JOA covers all of section 8 of 20 South, 29 East as well.
And is Mewborn proposing to give production from this unit to those owners in section 8 as well?
Yes, they're listed on that table on page 21.
Yeah, I guess to start with, if I were to ask you on your page 15 of 31, if I were to ask you to break out and provide a interest for the entirety of the unit, do you understand what I'm asking for?
For the entirety of the unit that's being pooled, specifically in this case, preparation unit, or for the entire JOA area that is larger than this? What are you asking for?
Well, I mean, I'll be frank with you. This is novel to me that a operator is attempting to say a person does not own an interest within the pooled unit and then is trying to attribute to them an interest. So I don't know if the best course would be for you to show me a breakout of ownership within the unit itself, and then a breakout of what Newborn is proposing to allocate production to. I guess, do you understand what I'd be asking for if Newborn were to provide two separate tables?
Yeah, are you asking for the ownership for each of these specific tracks, 1, 2, and 3? The operating rights and who owns that?
I guess, Mr. Anderson, that would be, one of the tables would be a unit recapriciation table that provides all of the interest owners and their share in the unit as one table. I was going to say in all the other cases, these are only the persons that own an interest within the unit. And then I guess if Newborn is proposing to allocate their production differently than that, then I guess that would be where a second table would come in, where I'm trying to figure out, who it is Newborn is proposing to allocate to.
So you're wanting a breakdown of all the contractual owners in this larger unit and what they own spread contractually across these tracks?
Well, if
because
they've
signed a JOA?
If they own a contractual interest in these tracks, then yeah, I want to see which tracks they have an interest in. And we need all these tables to match.
Okay.
So, I mean, if there's some sort of contractual interest that they own in the track, we want to see that broke out.
Okay.
And you understand that we would want to see, all these tables, I don't understand why they would not match. I guess, do you have a reason for why?
Yeah, really, because page 13, the two parties that were pooling own operating rights in these tracks. They don't own contractual interest because they have not signed a JOA. So therefore, we listed the operating rights interest owners for these tracks on page 13. Because those are the parties that own here, and the ones that can be pooled because they have not signed a JOA. But if you scroll down, go ahead.
Mr. Anderson, I guess, and excuse me because I'm not a landman, so I just trying to understand, what you're getting at. But I guess what I'm now starting to understand is you're saying there's other interest owners that has a contractual, working interest within these tracks, correct?
Yeah, and those are all parties that have signed a JOA that have been spread contractually into these tracks, and that table is listed on page 21.
Do those persons own a working interest in these tracks, whether it's contractual or otherwise?
Yes.
Okay, so if I were to ask you to show me a full list of everyone with a working interest within these tracks, including contractual, do you understand what I'm asking for?
Yes.
Okay. And in addition to that, I guess looking back at your recapriciation table then, with that in mind, it's not two separate tables. It would just be a singular table that gives us a recapriciation of everybody with a working interest within the proposed unit. Do you understand, where we're at there then? Okay. So then if I go back down to your commitment table down on page 21 of 31. So this list here, though, would stay the same because this is all the people that has a working interest or contractual working interest in the proposed unit.
Yes, sir.
Okay. So then would you understand then if I asked for those prior two exhibits to be amended, that being your recapriciation table and your track breakout table. Do you understand what I'm asking for?
Yes, you're asking for every party that owns an interest, contractual or operating rights, to be listed under this, under the page 13 and page 15 to be listed in what they own.
Okay, and Mr. Anderson, it appears that this is the case for, or this circumstance is present in both cases 26158 and 26162. Do you
Yes, sir.
agree?
Yes.
Okay, so you understand that I would be asking for an amendment to these exhibits in both of these cases, correct?
Yes, sir.
Okay. Thank you, Mr. Anderson. Mr. Hearing Examiner, I don't have any further questions, but I think this would be an instance that we should continue the case to allow time for review of the submitted exhibit packet.
Ms. Hardy?
That's fine. I expect we could get that information in today, but if Mr. McClure wants time to review, I understand.
When is, Mr. McClure, when's the next docket that you're involved in?
I mean, I could be involved in whatever docket. I'm sure I can show up.
Okay, all right. Freya, when is the next docket we could assign that Ms. Hardy could continue these two cases to?
I believe we have a docket on August 18th. I'm just double checking that it hasn't been vacated.
All right, take your time. Ms. Hardy, does that date work for you?
That does. Thank you.
It's still active, so it could be August 18th.
So, Ms. Hardy, if for some reason, I'm assuming that August 18 is a docket that it's a special docket?
Yes.
All right, Ms. Hardy, we'll hear it on August 18 unless the docket is vacated. If it is, we'll administratively move your cases to the next docket that Mr. McClure can attend, okay? But we'll try to hear this as soon as we can.
Thank you.
That being the 18th. Okay. All right. So we're off the record in 26158 and 26162. Thank you, Mr. Anderson.
Thank you.
Yes. Okay. It looks like we're moving on to case 15. This is another Mewbourne oil case, 26182. Looks like it's joined to 84.
And Dana Hardy on behalf of Mewbourne.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of MRC Delaware Resources LLC, and we are just preserving rights.
Thank you. Go right ahead, Ms. Hardy.
Thank you. In these cases, Mewbourne seeks to pool uncommitted interest in the Bone Spring Formation underlying the north half, south half, and south half of sections 23 and 24, Township 18 South, Range 30 East in Eddy County, and will dedicate the units to the Juice Box Fedcom wells. Our exhibits were timely submitted and include the land testimony and exhibits of Josh Anderson, who's previously testified, and also the geology testimony and exhibits of Charles Crosby, who has also previously testified as an expert. Our notice testimony shows that notice was timely sent on July 13th, 2026. With that, unless there are questions, I ask that the exhibits be admitted and that these cases be taken under advisement.
Thank you, Ms. Hardy. You mentioned notice was sent July 13th. Is that actual notice or constructive notice or both?
That was actual notice.
Okay. You didn't need constructive notice?
Right.
Okay. All right, admitted without exception. Mr. McClure, do you have questions for Mr. Anderson again?
Yes, Mr. Examiner. Essentially a repeat of the last two cases, except we can get to the point much quicker this time.
All right, no worries. Mr. Anderson, I remind you, you're still under oath. Go right ahead, Mr. McClure.
Mr. Anderson, is it correct to say that within your REIC appreciation table and track breakout tables, that there's contractual working interest owners that are not included?
Yes, sir.
Okay, so you would understand if I ask for these exhibits to be amended to include all working interest owners, including contractual ones. Is that correct?
Yes, sir. Yep.
Okay. And is it also correct that your commitment table on page 20 of 29 includes all the working interests, including contractual working interests? Is that correct?
Yes, sir.
Okay, thank you, Mr. Anderson. Mr. Hearing Examiner, I have No further questions, although I'd like for us to dispose of these cases in the same way as the last two.
All right, thank you, Mr. McClure. Ms. Hardy, same disposition. You'll continue these two cases to August 18?
Yes.
With the understanding that it's possible that they're not heard on the 18th, but
Yes,
we'll
thank
do
you.
our best.
Thank you.
We're off the record in those two cases. Thank you, Mr. Anderson. All right, let's move on to now 17 through 21. I'm going to call the numbers. It looks like they've all been dismissed. All right, these are Matador Production Company's cases for amendments. 26159, 6061, 63, and 64. Entries, please.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, MRC Permian Company. There are no other parties in these cases. They were approved administratively yesterday, and we filed a notice of dismissal.
Perfect, thank you. Okay, thank you very much, Ms. Vance. We're off the record in those cases. Let's move on now to Permian Resource number 22 on our docket, 26179.
Jackie McLean with Hardy McLean on behalf of Permian Resources, and there's no other party that's entered into
Thank you, Ms.
appearance.
McLean. Go right ahead.
Thank you. In this case, Permian Resources is seeking to pull all uncommitted interest in the Bone Spring Formation underlying a 960-acre, more or less non-standard overlapping spacing unit comprised of the south half of Section 22 and all of Section 27, Township 20 South, Range 35 East in Lee County, and this will be dedicated to the Mallard-fed COM U-turn wells. Exhibits were timely submitted and include the land testimony and exhibits of Reagan Armstrong, who has previously testified before the division and has been recognized as an expert in petroleum land matters. And we've also got geology testimony and exhibits from Cole Hendrickson, who has also previously testified before the division and has been recognized as an expert in petroleum geology matters. Finally, we've included notice testimony along with copies of the notice letter, which was sent to all interested parties on May 11th and July 16th, and an affidavit of publication from June 7th and July 22nd. With that, I ask that the exhibits be admitted for case 26179 and that the case be taken under advisement.
Admitted without exception. I believe we can take this case under advisement with a couple of corrections. Mr. McClure?
Thank you, Mr. Hearing Examiner. Yeah, I have questions for the landman.
Okay. Would you call your landman?
Yes, Ms. Reagan Armstrong.
Good morning.
Good morning. I'm waiting to, there you go. Would you raise your right hand, please? You
Yes.
swear or affirm under penalty of perjury, the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. Would you spell your name, please?
Reagan Armstrong, ReaganArmstrong.
Thank you. And you've previously been admitted as an expert in petroleum land matters by this division?
Yes, sir.
Thank you. Mr. McClure?
Thank you, Mr. Hearing Examiner. Ms. Armstrong, I'm looking at your NSP notice table, Exhibit A2 on page 16 of 95.
I can give me 1 second and I'll share this.
Thank you, Ms. McLean.
Why is it not pulling it up? Oh, it's because. Okay. Why is it not? There it is. Okay, what page was that again, Mr. McClure?
16, Ms. McLean. You see what we're looking at, Ms. Armstrong?
Yes, sir.
Okay, just to confirm, that box that's, or table, or list that's in a box in the bottom right-hand corner that says fee, that would be the ownership within your lease number 2, is that correct?
Yes, that's correct.
Okay, and then the interest held by these persons, is that working interest and or operating interest? Is that what that
Correct.
list
It's
comprises
working
of?
interest owners, yeah.
Okay. And
We
then,
operate that lease, so I was just listing all working interest owners for y'all since we couldn't obviously alert another operator.
okay, thank you, Ms. Armstrong. For the box, the smaller box that is just to the bottom left of that, is that the box for leases 3 and 4? Is that correct?
Correct.
And then is that also the working interest owners within those leases?
Correct.
Okay, thank you, Ms. Armstrong. Mr. Hearing Examiner, I have nothing further for this case, and I think we can take it under advisement.
Great, no
Thank
corrections needed. Thank you, Ms. McLean.
Thank you.
All right. Move on to 23, Coterra Energy, 26183.
Good morning, everyone. Dina Bennett on behalf of Coterra Energy Operating Company.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the MRC Delaware Resources LLC, and we are just preserving rights.
Thank you. Ms. Bennett?
Thank you. In this case, Coterra seeks an order from the division approving a non-standard spacing unit, pooling all uncommitted mineral interest owners, and to the extent necessary, approval of an overlapping spacing unit. And we've provided the usual suite of exhibits, including the exhibits of Trey Roberson, who's previously testified before the division, and his credentials have been accepted as a matter of record. And in his exhibits, we've included the non-standard unit exhibits, including a notice list and an overlapping notice chart showing that notice was mailed to the overlapping spacing unit interest owners. And then we've also included Exhibit B, which is a self-affirmed statement of Josh Day, a geologist for Coterra, and he's previously testified before the division, and his credentials have been accepted as a matter of record. And then Exhibit C is a self-affirmed statement from myself showing that notice was timely mailed on May 14th and July 14th, and that notice was timely published on May 20th and July 17th. We did 2 different mailings and publications to account for all of the different interest owners in these and offsetting owners. And one quick note, I'd like to, well, 2 quick things to say about these cases. First, when I submitted the application for these cases, we were under the impression that the wells traversed 3 pools, which is in fact, I think, correct. But in the application, I had put the Buffalo pool as one of the pools, but it turns out it's the Tees Bone Spring pool. So I corrected that in the compulsory pooling checklist. And then if there are any questions for our landman, Mr. Robertson, he is unavailable today, but we have another landman who's able to step in and answer any questions if there are questions for the landman. So with that, I would ask that the exhibits in case number 26183 be admitted into the record. And if there are any questions I can answer, happy to do so. And if the division has questions for any of the witnesses, we will make them available.
Admitted without exception. Mr. McClure, I believe you want a depth severance correction?
Oh, that's correct, Mr. Hearing Examiner. No questions, but just guidance from Ms. Bennett regarding the CPAC.
Great. Happy to hear it.
Ms. Bennett, I think we might have discussed the topic in one of these recent competing cases, but if you're looking at your CPAC specifically where it talks about the depth severance, I don't know if you have it right in front of you or not.
I do. Yeah, I do.
Yeah, essentially, rather than a repeat of like the vertical extent, what we're looking for there is a description of both points at where the ownership changes. So instead of like a single sentence like that, you would have, there's a depth severance at 10.216. And then like another sentence, there's a depth severance at 10.782. Do you see what I'm referring to, Ms. Bennett?
I do. And I did look back at what I had prepared before, trying to learn from my past foibles, but I apparently did not take the lesson to heart. So I will do a better job. And I think the only question I would have is, I understand the depth severance at 10.216. The 10.782 is the base of the third bone spring. So I'm not sure if that's
okay.
necessary.
Yeah. Good. Well, yeah. Good point, Ms. Bennett. I guess I wasn't understanding that was the. Yeah, I guess I do see when I'm reading it a little bit better that would be defined as the base of the second bone spring to the base of the third bone spring. Sand. Okay, I guess I'm in agreement with that. So yeah, I'm in agreement with what you just laid out. I guess the only depth severance that would fall within the Bone Spring Formation then would be your 10-216. Then I'm in agreement. So essentially, your intended submission. What are you intending to submit to us?
Well, I would submit something that says there is a depth severance at 10-216 TBD as found on the Halliburton dual spaced neutron spectral density log, et cetera.
Okay, sounds very good. And that's something you'd be able to provide to us by the end of the day?
Definitely.
Okay, thank you, Ms. Bennett. Mr. Hearing Examiner, I have nothing further on this case.
So, Ms. Bennett, we'll leave the record open until 5 p.m. today. Thank you.
Thank you.
We're off the record in case number 23. Let's go to case number 24, Matador Production. It looks like it's joined to two other cases, 26191, 92, and 93. Entries, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, MRC Permian Company.
Good morning, Mr. Examiner, Dina Bennett on behalf of Avant Operating 2 LLC. And Avant Operating 2 is not objecting to the cases, subject to further confirmation from Ms. Vance that I understand that MRC and AO2 have reached an agreement. And so with that understanding, Avant is not objecting to the cases moving forward.
Thank you.
But I look forward to the confirmation on the record.
I gathered that. Thank you. Ms. Vance.
On the outset, I will just go ahead and allay Ms. Bennett's concerns. Yes, the parties have reached a letter agreement, and so we will plan to file, if it's okay with the division, unless there's other stuff we need to also correct, but we will file revised hearing packets that reflect that Avant is not being pooled.
I think this case can be held open until 5 p.m. for that correction and maybe a couple of others that Mr. McClure may have for you. So why don't you present your case and we'll move forward.
Perfect. So in these cases, the acreage involved is all in Township 25 South, Range 36 East, and that's in Lee County, New Mexico. In case number 26191, Matador MRC is seeking to pool a 480-acre west half horizontal spacing unit, and that consists of, and that's in sections 10, 15, and 22 in the Bone Spring Formation, and initially dedicate this spacing unit to the Rays Creek FedCom 81H. In case number 26192, MRC seeks to pool a 480-acre east half west half horizontal spacing unit. Again, that's sections 10, 15, and 22, Bone Spring Formation, and initially dedicate that spacing unit to the Rays Creek FedCom 91H. And then lastly, in case number 26193, MRC seeks to pool a 480-acre west half horizontal spacing unit in sections 10, 15, and 22, and that one is in the Wolfcamp Formation, and initially dedicate that to the Rays Creek FedCom 111H. In our hearing packet, we have included the statement from our landman, David Johns, and then our geologist, Liz Olson, both of whom have previously testified before the division, and their credentials have been accepted as a matter of record. We have included the required sub-exhibits for both land and geology, and then following that is my self-affirmed statement of notice. And there are a couple of letters in there dated May 15th, 27th, and then July 17th, 2026. And then notice of publication, the affidavit there. We've got three of those that are dated May 19th, June 12th, and July 21st. 2026. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement at this time.
Admitted without exception. Mr. McClure?
Thank you, Mr. Hearing Examiner. Ms. Vance, I'm looking at your first two cases, the Bone Spring ones, 26191 and 26192. I'm looking at your CPAC on them. I don't know if you have one of them in front of you or not.
Yes, I do. I've got both of them up.
Sweet. You see where on the it says it's pulling this vertical extent entry there?
Yes.
The pool that covers these, this area for the Bone Spring is subdivided between the upper and lower Bone Spring. So we would need to correct this vertical extent to now state either the lower Bone Spring, or you can get more detailed and say it's from the top of the first Bone Spring sand to the base of the Bone Spring. Either would be acceptable.
Okay, now would this be something that we could reach out, either discuss with you offline to confirm based off of their landing, which pool it lands in, and then make that correction? How would you like to, I mean, you tell me how you'd like to proceed, because I guess I wouldn't know unless we get confirmation from the district geologist.
Well, I suppose what the easiest route would be is for, I mean, in regard to the pool, I can tell you what the pool is. That's not a big deal.
Okay.
But, you know, towards that end, we could bring your geologist on and confirm where these wells are landed at.
Our geologist is available, and that way we can confirm and know which pool, and then I can make that correction.
Okay, yeah, that might be a good idea. Mr. Hearing Examiner, if maybe we could ask the geologist some questions.
Do you want to call your geologist, Ms. Vance?
Yeah, yes, Ms. Olson should be available.
Okay. Would you raise your right hand, Ms. Olson? Do you swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Thank you. Would you spell your name, please?
Lizolson.
Thank you. And you've been admitted by this division as an expert in petroleum geology?
Yes, sir.
Perfect. Thank you, Mr. McClure.
Thank you, Mr. Hearing Examiner. Ms. Olson, I'm looking at like your cross section, like Exhibit D3. In the first case, it's page 55 of 70.
Yes, sir. I'm there.
Okay, Miss Olson, I guess, is this like highlighted area that's towards the bottom there? Is that representative of where the lateral for these wells is going to be completed in?
Yes, sir. Both for the 081 and the 091.
Okay, and what would be the horizon or the bench within the Bone Spring that this is falling within?
These will be third bone sand wells.
Okay. Is this accurate for, I mean, I know we're looking at one of the cases here. Is this accurate across both of the, or is this the same for both of the Bone Spring cases?
It's the same landing zone for both of the Bone Spring cases.
Okay, so to your understanding, if the vertical extent of the unit were to be constrained to from the top of the first Bone Spring sand to the base of the Bone Spring, that would be inclusive of where the applicant intends to complete the wells and produce from?
Yes, sir. That'd be correct.
Okay, thank you, Ms. Olson. I guess, Ms. Vance, did you want confirmation of the pool code that it's going to be landed within? Is that what you were asking before for?
That would be great, but I would also ask for the it to be emailed to me, so I don't have to scribble it out. If that would be okay. Since one of the other technical examiners offered to do that.
Oh, Ms. Vance, can you scroll up on where you're at just a little bit?
Sure.
Do you see? Oh, scroll down. Oh, I guess it's there too. Do you see where it has like that pool? Yes, Ms. Vance, that is the correct pool right there. With that in mind, okay, very good. And you understood what I was asking for on the CPAC, is that correct?
Correct. Now, since this is an upper and lower, do you want me to go ahead and just put in there from the base of the first Bone Spring to the base of the Bone Spring and then just include that pool code?
Well, it's not needed for you to include the pool code, but you definitely may include this pool code and pool name within the CPAC. Your description, though, of the lower Bone Spring would be incorrect.
Can you let me know what you'd like me to put?
Yeah, the lower Bone Spring is defined as from the top of the first Bone Spring sand to the base of the Bone Spring.
Okay.
So with that in mind, I guess what would you be submitting to us or proposing to submit to us?
So we will update the CPACs with that language in the vertical where, let's just go to it so we're both on the same page. Right here, pulling this vertical extent, and I will put from the top of the first Bone Spring sand to the base of the Bone Spring on both of our, case number 26191 and 92. And I can submit that by this afternoon. And then unless there's anything else aside from us also updating the pooling exhibit.
Yeah, and that was the only other thing I was going to ask you, Ms. Vance, is can you describe what that amendment is going to consist of?
So for case 26191, I will update the CPAC and make notation in the line item for the vertical extent based off of what we just spoke about. And then I will also update our exhibit, should be exhibit C3, and you'll see AO2 Permian LLC, that's Avant, and I will unhighlight them. And then the same thing for 26192. And then lastly, for our Wolf Camp case, I will just be updating that exhibit C3, the pooling exhibit, and unhighlighting Avant to reflect that they are no longer being pooled.
Okay, thank you, Ms. Vance. Mr. Hearing Examiner, I think we should be fine with leaving the record open till the end of the day and then take it under advisement.
Thank you, Mr. McClure. Ms. Vance, is that doable?
Yes.
All right. For all three cases?
Correct.
Okay, very good. We're off the record in those cases. Let's move on to, looks like case number 27 on the docket. This is Mewburn Oil. There are two cases joined, 26224, 26225.
Jackie McLean on behalf of Mewburn Oil Company, and there are no other parties that have entered an appearance in this case.
Thank you, Ms. McLean. Go right ahead.
Thank you. In these cases, Mewburn is seeking to pull all uncommitted interest in the Bone Spring Formation in sections 5 and 6, Township 21 South, Range 26 East, and Section 1, Township 21 South, Range 25 East in Eddy County, and the units will be dedicated to the Ophelia 5-1 Fedcom wells. Exhibits were timely submitted last week and include land testimony and geology testimony and exhibits from Ariana Rodriguez and Charles Crosby, both of whom have previously been recognized as experts in their respective fields by the division. And we've also included our notice testimony along with copies of the notice letter, which was timely sent to all parties on July 15th, and an affidavit of publication from July 22nd. With that, I ask that the exhibits be admitted for case numbers 26224 and 26225, and the cases be taken under advisement.
The exhibits are admitted without exception. Mr. McClure, your questions?
Yeah, Mr. Hearing Examiner, I'll have questions for the landman for the first case, and then we have the notice issue that we need to address with Ms. McLean.
Okay, so the landman for the first case, not the second case.
So 26224, it's the same Ariana Rodriguez.
Perfect. Do we have Ms. Rodriguez?
She should be.
Here. Can you hear me?
Yes.
There you are. Ms. Rodriguez, would you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Would you spell your name?
It's Ariana Rodriguez. It's ARIANA RODRIGUES.
Thank you. And you have been previously admitted by this division as an expert in petroleum land?
Yes, sir.
Thank you. Go ahead, Mr. McClure.
Thank you, Mr. Hearing Examiner. Ms. Rodriguez, I'm looking at your, it might be easiest just for us discussing. I'm looking at your lease map here found on page 12 of 70.
Yes.
And do you see that track number 2, essentially that unleashed federal interest in the, I guess I don't know how best to describe it, lots 25 through 28, I guess.
Yes.
Okay, can you provide me with a little bit more information regarding that track?
It's an unleased BLM tract, and we reached out to the BLM because we have a proximity tract well, and they had us set up an unleased lands account off with that serial number, that 106812425.
Okay, so then is it the applicant's intent? Is it essentially like the production that would be attributed to that lease? Is that going to be set up in escrow or something like that? Is that the thought process?
It's set up in the unleased lands account that we got approved with the BLM.
Okay, but does the BLM plan on leasing that tract, I guess?
I can't speak for the BLM. I can't speak to they gave us that unleased lands account, that serial number to use for these wells, and so that's what we're doing.
Yeah, and I understand where you're going there. Would it be Mewbourne's intent to, if that acreage gets leased, would it be Mewbourne's intent to then force pull that person later if they don't sign into these wells?
I think with an unleased lands account, and I'd probably have to defer to our attorneys, but I think with that unleased lands account, it is included in the wells, like the person that production and all the revenue goes to that unleased lands account. I'd have to ask our attorneys how that works.
And that's understandable, I guess. So then you don't know what would happen if if an operator were to lease out that lease at a later point. Would that be accurate to say?
I don't know. That would be a question for the attorneys.
Okay.
We've reached out to the BLM and we've set that account up with them.
Now, it is correct that the applicant is not requesting the division to force pull any entities in regards to this tract, though. Is that correct?
Correct.
Okay, thank you, Ms. Rodriguez. Mr. Hearing Examiner, I don't have any further questions for either of these cases. Just discussion with Ms. McLean now.
Go right ahead.
Ms. McLean, I'm looking at, essentially the last page in both of these cases, your affidavit of publication, specifically the newspaper clipping.
Yes, I have it up.
I know this had come up on a prior case, and in that instance, I believe the public notice was not necessary. However, I believe the public notice is necessary in both of these cases. Do you agree?
I would need to refresh my memory on these to see if everyone got a delivery receipt or not. Yeah, it looks like
I mean, there were definitely
Looks
ones
like there
that
was
were,
some that were forwarded, so I'll just take your word for it that not everyone did. So what's the issue with the publication, I guess?
well, this has the same issue that we were talking about in that prior case, and that is, if you'll notice, it seems the newspaper, or I'm assuming the newspaper, removed your dashes from between the lots. Do you see where I'm referring to? Like, I mean, there's several instances kind of in the middle. There's like that 2730. It should have said 27-30. There's like 2532. Should have said 25-32. I'm assuming is what
yeah.
you sent the newspaper.
I see that. It says 3134. Yes, I see that.
We will need to conduct new public notice that has that corrected. I don't know if maybe you want to put in there, you know, like 25 through 32 or 25 to 32
Yeah.
or something along those lines if the newspaper is going to keep doing that to you.
Yeah, it's weird because in the proofs that like we get, it still has the dash. So I don't know, because I review all of it. So I don't know what happens when they actually print it, but I guess we will do that.
I mean, I'm assuming this newspaper clipping is the accurate
Yeah, and
representation
this
of what ultimately ended up being there.
Yeah, and they send this to us attesting that that is the case. So I would have to
Well,
believe
that's
that's correct.
What?
Okay, so we will do the newspaper publication. I'm thinking because it's, you know, well, it depends. Which one is this in? The Carlsbad, I think they're only running the paper there on Wednesdays now. So we would have to wait until next Wednesday. And then 10 days, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. There is a hearing on the 20, I was looking at the hearing dates. So I guess we would just need to do, well, would we need to come back or could we just submit it because it's just that publication? Would you be able to review it without us coming back to a hearing? If we just submit it when the time ran for that?
Well, I know current procedure would be to actually call it in case there's anybody wants to, you know, do a entry of appearance, I guess. So my thought process would be we would want to continue it to another docket unless our hearing examiner, I guess, has additional thoughts on it.
Ms. McLean?
I mean, no one objected. I don't know if people usually do object based on the public notice. I was just trying to think of the easiest thing for everyone with something like this. The lots, you know, because the spacing unit description is what it is. But it's, you know, at your discretion.
Okay. What is the earliest docket this could be put on?
I think it's the September 1st, 2026. There's currently one case on that because the Carlsbad paper only publishes Wednesdays now. So the first time that they would be able to publish would be next Wednesday. It's not like we can do that today.
Got it. So you said September 3rd?
September 1st. It looks like there's a special docket on that date.
Let's put it on the 3rd because who knows what's going to happen.
Yeah,
the first,
it's just a couple days.
Parties at the last minute. You probably didn't know this, but parties at the last minute resolve
Never heard of that happening.
resolve their cases, and we don't come to a hearing. So just continue your cases to that docket. And Freya, would you see that it's at the beginning of the docket so we can dispose of it quickly?
Yes.
All right, thank you. All right, thank you, Ms. McLean. These two cases will come back and be heard on the 3rd. Thank you, Mr. McClure.
Thank you.
All right, let's move on to Matador Production Company. It looks like we have a few of these that are tied together, and not to spoil any surprises, but it looks like we're going to take them under advisement. So whosever cases they are, let's make them nice and quick. This is 29 through 34 on the docket, 26289, 90, 91, 92, 93, 94.
Well, we're going to throw a curveball at you, of course.
Why?
So we're going to present 3 of them.
Okay.
So I'll enter my appearance. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant. And I believe this one is MRC Permian. Anyway, I will let Ms. Hatley go forward.
Good morning, Mr. Examiner.
Morning.
Carrie Hatley entering her appearance on behalf of Marathon Oil Permian. And we are monitoring 3 of the cases. However, I am entering an objection in 3 of them.
Oh.
So I would like to orally object, and we'll follow up with a written objection to case number 26289, 26290, and 26293.
Hold on, let me just get this right. 2628990, and then skipping over to 93.
That's correct.
And you're representing Marathon.
Yes, sir.
Oh, okay. So those cases obviously can't go forward today. Freya, will you administratively move those to the status conference docket? That's going to be a long docket on the 20th.
Yes.
But that's life. Okay. All right. Thank you, Ms. Hatley. Are there any other entries? No. Okay. So you're going to present 91, 92, and 94 at this time. Is that right?
That's correct.
Go right ahead.
Thank you, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, MRC Permian. In the 3 cases that we are going to move forward with, all of the acreage is in 2 different townships ranges. We've got section 36, and that's section 36, township 22 south, range 27 east, and then section 31, which is an irregular section, and that's in township 22 south, range 28 east, and that's all in Eddy County, New Mexico. In case number 26291, MRC is pulling a 319.06 acre north half, south half. That's the Bone Spring Formation, and initially dedicating that to the Betty Jones Federal Com 123H. Case number 26292, MRC is pulling a 319.02 acre south half, and that's in the Bone Spring as well, and initially dedicating that to the Betty Jones Federal Com 124H. And then lastly, case number 26294, MRC is pulling a 478.0 acre north half of the south half of section 36 and south half of section 31. That's the Wolf Camp Formation. That involves approval of an overlap. We included the exhibit to go along with that, and that is initially being dedicated to the Betty Jones Federal Com 203H Candy Cane well. And we have included our land and geology statement. I will note that our geologist has not previously testified, and that is Mr. Brandon Hercher. So I'm not sure if you'd like to, if we can admit him, at least do that. He did include a summary of his experience and education in his affidavit. And again, as normal, we have included all the required sub-exhibits, followed by self-affirmed statement of notice, sample copy of the notice letter. Notice was timely mailed out on June 18th, 2026. And along with that, we've got our notice of publication that was timely published on June 24th, 2026. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record, and that those 3 cases be taken under advisement at this time. I will note there is one thing on case 26294. I will call this out on myself, but I did notice when I was reviewing these yesterday that on the CPAC, it says oil instead of gas, and this is in the purple sage, so we will update that so it reflects correctly.
So the exhibits are admitted without exception, and as I said earlier, Case 91 and 92 are taken under advisement at this time. Mr. McClure, do you have any questions in case 26294?
Yes, I do, Mr. Examiner, for the landman.
Landman, would you call your landman?
Yes, Mr. Addison Costley.
I'm here.
Did you turn your microphone on, Mr. Costley?
Yes, sir. Can you hear me?
I'm sorry, did you, there you go, okay. It says Liz Olson. I recognize you, though.
Yes, sir.
You've testified before as an expert in land matters. So would you raise your right hand, please? You swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes, sir.
Great. Would you spell your name?
Yes. Addison Costley, Addison, Costley, Costley.
Okay. Mr. McClure, I recognize him as the expert in land, so I don't have to ask that question. Go right ahead, Mr. McClure.
Thank you, Mr. Hearing Examiner. Mr. Costley, I'm looking at, I mean, it might just be easiest just so we have something we're looking at, and that's page 35 of 47. It's essentially like your, I guess maybe this is like the NSP map. I guess maybe it's part of the Geo exhibit, but this might be the easiest thing to look at. Do you see that, like the blue, is it accurate to say that the blue area is what the applicant's asking to force pull in this case? And that the red area is the accepted or the removed area from the standard HSU?
That is correct.
But it's accurate, I believe, from your statement, but just to confirm, that the applicant owns 100% of the working interest within the south half of section 36, or that red area there?
That is correct.
I guess, why is the applicant asking for an NSP to exclude that rather than just including it all in the same unit here?
That's going to deal with the existing well that's located in the south half of section 36. It's an older well in the same target as the Betty Jones 203 that we are proposing. And so we felt like an NSP was appropriate to allocate for the candy cane being, 1/3 of it is in section 36 and 2/3 of it of the lateral will be in section 31.
I guess does Matador believe that the candy cane well is not going to drain from the south half of section 36?
I think with that existing well being in the south half already, that's already drained that area. And so that's why we're not including it.
I guess could you elaborate on that a little bit more? In terms of the reason to remove it. I understand that it's been producing for a number of years, but can you elaborate more on Matador's reason that would qualify it for removal from the unit?
Sure. I think, with the existing well being there, it has, been there for roughly 10 years or so. It's drained that acreage. The rest of the unit is undrained or unburdened in the Wolfcamp A. And so we felt that the proration unit should represent the, virgin rock rather than the drained rock. And so that's why we allocated the unit to just be in the untouched rock rather than the previously drained rock under the Scott Walker 204 within the south half.
Well, I guess did Matador, to your awareness, did Matador submit any evidence demonstrating along that line that it is in fact is drained, therefore it should not be included, anything like that?
I do not believe so. I'm not aware of anything, so.
Okay, thank you, Mr. Costley. Thank you, Mr. Hearing Examiner. I don't have any further questions. I believe we can take it under advisement with the record left open till the end of the day for that correction to the CPAC that Ms. Vance had mentioned.
Thank you, Mr. McClure. Ms. Vance?
Yes, I can get that done.
Okay, we're off the record in those cases. Okay, let's move on to case number 35 on the docket, which is joined to two other cases. This is 26295 Matador Production Company, joined with 96 and I guess 97. Who's representing Matador? Oh, you are. Oh, I didn't hear you. Do you want to take a 2-minute break or something?
No, actually, but before the last case.
Your microphone's not been on for this whole time.
Sorry about that. No, I'm good to move forward. Sorry, just shuffling a couple of papers. Good, if it's still morning, good morning. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, MRC Permian Company.
Thank you, Ms. Vance.
Good morning, Mr. Hearing Examiner. Yaditza Pena on behalf of COG Operating LLC, and we are just monitoring.
Thank you, Ms. Pena.
Thank you. Oh, I'm sorry.
Sorry, it's hard to see. Good morning, everyone. Ben Holiday appearing on behalf of Powderhorn Operating. We're in case number 26296 only. No objection, just preserving rights. Thank you.
Thank you, Mr. Holiday.
Thank you. So, and I will say on the outset, I don't know why I keep saying offset, and I think it's just like the nature of the work. But at the outset, we will be filing revised hearing packets. One of the items is related to Mr. Holliday's client. Matador and Powderhorn have reached an agreement, so Powderhorn is no longer being pooled. So we will be updating that pooling exhibit. And then I'll go through a couple of other updates that we'll need to file revised hearing packets for.
Okay.
So in these cases, the acreage involved is all in Township 18 South, Range 24 East, and that's in Lee County, New Mexico. In case number 26295, MRC is pulling a 318-acre west half of a regular Section 18. That's in the Bone Spring Formation. This does include approval of an overlap, and this is the pooling is limited to a depth of 11,044 feet total vertical depth to the base of the Bone Spring Formation. And Matador seeks to initially dedicate this spacing unit to the Mark M FedCom 130H. And then in case number 26296, the exact same acreage overlapping, but in the Wolf Camp, and Matador seeks to initially dedicate that to the Mark M FedCom 210H, and that's another U-turn well there. And then lastly, in case number 26297, Matador is pulling a 320-acre east half of irregular Section 18, and that involves the Wolf Camp Formation, includes a overlap approval, and is limited to a depth of 12,242 feet total vertical depth to the base of the Wolf Camp Formation, and then initially dedicate that to the Mark M FedCom 229H U-turn well. We have included the self-affirmed statements of our landman and geologist. Both of Mr. David Johns is our landman and our geologist is Blake Herbert. Although I will note if there are questions on geology, Mr. Herbert is not available today, but Ms. Olson is available, who you've already heard from earlier. Both of our experts have previously testified before the division, and their credentials have been accepted as a matter of record. And we've included all the required sub-exhibits. And then following that is is a self-affirmed statement of notice along with a sample letter that was timely mailed on June 18th, 2026, along with a notice of publication that was filed on June 21st, 2026. I'm gonna just go through the corrections, the updates for each of these. So on, and our landman is available, who can also speak to this. So basically, there were some leases taken after the application was filed. So, and there were some subsequent to getting to hearing, there have been some updates, some new leases taken. So essentially, and I can walk through the specifics of those, but basically what I'm telling you is we are planning to file revised hearing packets with a updated pooling exhibit, an updated commitment status, and chronology of contacts to make sure to note the parties that were the owners at the time of filing, but the parties that have taken subsequent who Matador has been in contact with regarding the pooling process. So I can go into the specifics, you can ask our landman, but that's sort of the general overview. I will note specifically though, a couple of key people here though. In case number 26295 and 26296, at the time of filing, George Lynn Sims was the owner of the interest being pooled. And so that individual was provided notice. That was recently leased by Ballum Resources. So you'll see George Lynn Sims on the tracking report as having received the notice. And then on the pooling, the communications, and the commitment status, Ballum Resources is listed. So we'll just make that clear in the exhibits that that George Sims was the party of record at the time of filing the application. And then that interest has been subsequently leased. And so Matador listed them on the pooling exhibit as owning the interest and has been in communication with that party subsequent to moving forward with the cases. And then similarly, in case 26297, the original interest owner at the time of filing the application was West Bend, and so they show up on the tracking report as receiving the notice going to them. But on the pooling, the communications and the commitment, Lone Tree Resources is listed because they are the new party that leased that interest. We'll just make that clear in there, and I will make sure that it's covered in the cover page. So it's easy for the technical examiner to follow the changes of interest subsequent to filing the application. So unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that the cases be taken under advisement at this time. And of course, we're ready for questions if the examiner has any.
Admitted without exception. Mr. McClure?
Thank you, Mr. Hearing Examiner. I'll have questions for the landman, but if I may ask Ms. Vance one clarifying question real fast before we do that.
Go ahead.
Ms. Vance, just to confirm, I believe this is what you said, but just to confirm, the persons that received notice, those were the interest owners that were known at the time of the application being submitted. Is that correct?
Yes, they were the parties of record at the time of filing the application.
Okay, thank you, Ms. Vance. Mr. Hearing Examiner, I guess if I could ask the landman some questions.
Okay, I see a gentleman here on the screen. Who is that, Ms. Vance?
That is our landman, Mr. David Johns.
David who?
Okay.
David Johns.
Johns. Thank you. Mr. Johns, would you please raise your right hand? Do you swear or affirm under penalty of perjury the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes, sir.
Thank you. Would you spell your name, please?
David, D-A-V-I-D, Johns, Johns.
Thank you. And you've previously been qualified as an expert before this division?
Yes, sir.
In what field?
Land.
Thank you. Go right ahead, Mr. McClure.
Thanks, Mr. Hearing Examiner. Mr. Johns, like I'm looking on your self-affirmed statement, page 12 of 47 in the first case here, specifically at your paragraph 13 where you talk about unlocatable persons.
Yes, sir.
Okay, and well, I don't know about this case. Which case are you in, Ms. Vance?
Sorry, which case number? Oh, I'm on Betty Jones. I'm sorry.
Okay.
Sorry. What page number was it, Mr. McClure?
Page, I might have said 13, but it's actually page 12 of 47. And this is for the case 26295.
Yes. Okay, that should be correct.
In paragraph, yeah, makes sense. Yes, Miss John or Mr. Johns, are you with us here now?
Yes, sir.
It appears that cold water land service was unlocatable. Is that correct?
Yes, sir. That's correct.
Okay, and this isn't one of the persons that is associated with the changes that Ms. Vance was talking about. Is that also correct?
That's correct. They're not associated with those changes.
Okay, and is this the only interest owner that was unlocatable?
That's correct.
Okay. And I know Ms. Vance brought it up, but could you give me an extremely brief description or summary of what's going on with Balaam Resources LLC?
Yes, sir. George Lynn Sims originally owned an unleased mineral interest in case number 26295 and case number 26296. They were noticed, and in the last 2 weeks, they executed a lease to Balaam Resources. So Balaam Resources has been included and updated in all of the exhibits, and we've been in contact with them.
Okay, so then notice wasn't provided to Balaam because it was provided to the person who owned the interest prior to them. Is that correct?
Yes, sir.
And could you say one more time who that interest owner was that was provided notice for this interest?
George Lynn Sims.
George Lynn Sims, is that correct?
Yes, sir.
Okay. Okay, now I'm looking at your, and unfortunately I didn't include page numbers in my notes for this, but I'm looking at your commitment table. Let me get scrolled down to it. Maybe Miss Vance has it. Looks like page 34 of 47. Oh, yeah, Miss Vance already has it. Are you with us, Mr. Johns?
Yes, sir.
Okay, do you see on there where you have like two persons that's listed as being committed in white there?
Yes, sir.
Okay, you see on the right-hand column where you only say committed, correct?
Yes, sir. They've signed the JOA.
Okay, and do you understand, I guess, that what the division's looking for there is the commitment type? So you would say, I mean, you can say committed there if you don't want to have a different column, but like committed dash JOA, something along those lines, just so we know how they were committed.
Yes, sir. We can make that edit quickly today.
Okay, and then that was, and just to confirm, that's the case for Latam Energy LLC, that they're committed via a JOA?
Yes, sir. As long as Gassier Energy LLC.
Okay. Okay. Yeah, not to jump all over the place too awful much, but I'm back up at your self-affirmed statement, Mr. Johns. Specifically, I'm looking at the paragraph 4 on page 10 of 47 that discusses the depth severance.
Yes, sir.
Can you describe, I guess, from where that depth severance is derived?
There were historical leases that were taken that contained pew clauses, and the acreage below the 100 feet below the deepest depth drilled expires. So that if you'll look, you'll notice COG operates 2 Sebastian wells. So that depth severance is 100 feet below the Sebastian wells that are existing in the ground. And there's no depth severances below 11,044 feet that we're pulling. All the interest below that depth is uniform.
Okay, so then 11,044 feet is derived from being 100 feet deeper than one of the Sebastian wells. Is that correct?
Yes, sir.
Okay, do you include that Sebastian well, I guess, anywhere in your exhibits?
On page 15 of 47, we've got the overlapping unit map that contains the Sebastian FedCom 1 and the Sebastian FedCom 2.
Okay, I'm looking at the map that Ms. Vance has. So which one is the deeper one? The one in the west looks like 10,944. Is that correct?
Yes, sir.
Okay, so then would it be accurate to say that your 11,044 is based upon the surface location of the Sebastian Federal Com 1H?
It's based off of the deepest TBD of the Sebastian FedCom 1H. Yes, sir.
Yeah, but would it be accurate to say that the TBD of that well is connected to its surface location?
Yes,
Therefore,
sir.
you're
Yes, sir.
okay. And where is that surface location located at?
The surface location of the Sebastian FedCom number 1H well.
Yes, sir, Mr. Johns.
I'm not sure if those were drilled from north to south or south to north.
Let's see. Mr. Vance, do you know if there's an API number listed for that well anywhere? Well, I guess I can look up by the well name.
Yes, give me a second. It should be in the application. So the API numbers are right here. I was going to say, I'm sharing my screen, but otherwise I would look in the well file for you.
Your mouse is that 687?
Yeah.
Looks like the surface location is located in unit letter D, so of section 18, so the northwest quarter, it appears. So then, Mr. Johns, would it be accurate to say that your depth severance of 11,044 feet is in reference to the northwest quarter of section 18?
Well, that's where the surface location of the well is, but we the language of those pew clauses, it's the deepest depth drilled of that well. The surface hole is in D, as you guys confirmed, the northwest quarter, and then the bottom hole is in southwest.
Well, would it be accurate to say that essentially it is like the stratigraphic equivalent of that depth? Correct, would be the thought process?
No, it's not. The pew language isn't tied. The pew language in the lease is tied to a stratigraphic equivalent. It's just that it's the true deepest depth drilled of that subject well.
And does this depth severance, it would cover the entirety of the west half of section 18, that's correct?
That's correct. The depth severance of the formations were the depths that we're trying to pull, the 11,044 feet. That's correct. That would be for the entire west half.
If I were to ask you to provide us some additional written, like in your self-affirmed statement, if you could amend like your paragraph 4 to reference like where that 11,044 feet is coming from, kind of summarization of our verbal back and forth here today. Do you understand what I'd be asking for?
Yes, sir. We can do that today. And just to confirm, we could, paraphrasing, but just put that it's based off of 100 feet below the TBD of the Sebastian FedCom 1H.
Mr. Johns, yeah, that you have I would agree, I guess, with the thought process there.
Perfect. Yes, sir. That we can quickly add that today.
And you understand, or it sounded like you already said you did, but just to confirm, in regards to what I was referencing in the commitment table about putting the type of commitment on those?
Yes, sir.
Okay. Mr. Hearing Examiner, I don't think I have any more questions for Mr. Johns, but I will have some questions for their geologist or the substitute geologist.
Has the substitute geologist been admitted as an expert before this division?
Yes, and
Oh.
she already spoke earlier
Oh.
today, so she's already been sworn in. One question,
Sure.
just since we have a depth severance on both the 26295 and 26297, I'm assuming Mr. McClure wants a similar discussion in the landman statement for that case as well, correct?
Oh, actually, I do apologize, Ms. Vance, because some reason I didn't have it in my notes, but it was going to come up shortly because this is the depth severances is what my geologist questions are about. But yes, Mr. Hearing Examiner, if we can bring Mr. Johns back and briefly discuss case 26297.
Okay, let's take a 5-minute recess and then we'll be ready for Mr. Johns. Thank you. Off the record. Heard Mr. McClure?
I heard nothing. You've been in the privacy this entire time.
Ah, Mr. McClure, we're back on the record.
And we have our landman who's back up to answer any questions.
Thank you, Ms. Vance. Mr. Johns, in regards to the case 26297, is that a similar depth severance as to the Bone Spring case?
Yeah, similar situation, just different Sebastian wells and a different formation, but same general idea.
Okay, and I see in your self-affirmed, oh, maybe this is the application. Let me go down to your self-affirmed statement. Oh, actually, I guess I was looking at the overlap, which is just in your application, not your self-affirmed. In your application on page 7 of 47, it looks like there's like several Sebastian wells listed there. Do you know which one your depth severance of 12,242 is based on?
I believe it's the Sebastian FedCom number 704H.
I'm sorry, Mr. Johns, I missed the last number there. You said
704H, I believe.
Oh, 4H. Okay. It appears that that surface location would be located in the northwest of the northeast quarter of section 18. Does that sound right to you, Mr. Johns?
Again, I don't know offhand the surface locations of the Sebastian wells.
Good point, Mr. Johns. But it would be, okay, I guess it's a similar concept, though, to our prior discussion that your depth severance is based upon the deepest 100 feet below the deepest point of these two wells. Is that correct, Mr. Johns?
Yes, sir.
Okay. And then you would understand, or you already understood my prior request for the last case in regards to your self-affirmed statement corrections?
Yes, sir.
Okay. Thank you, Mr. Johns. Mr. Hearing Examiner, I finished asking questions of the landman this time, I hope, and ready for the geologist.
Okay, let's get the geologist back. Is it Ms. Olson?
That's correct.
Okay. Ms. Olson, I remind you that you're still under oath. Go right ahead, Mr. McClure.
Thank you, Mr. Hearing Examiner. Ms. Olson, I'm looking at your, I'll just start with this East Half Wolfcamp case because that's the one I have open. So case 26297. I'm looking at your cross section on in Exhibit D3, page 40 of 47.
Yes, sir, I'm there.
And do you see where Matador has, or this exhibit has, like that dashed line for the depth severance wrote at like, it just says like 12,242? You see what I'm referring to?
Yes, sir. I do.
I guess, do you think this is an accurate representation across that cross section as to where that depth severance would exist?
I think that's definitely accurate on the middle type well, the government L2, which is on section for the Sebastian federal wells. And I think it's just a TBD representation otherwise.
Okay. Yeah, so And I'm looking at your map directly above to show where your cross section's coming from. And it looks like the depth would be based off of the northwest quarter or the northeast quarter. So with that in mind, would you agree that that total vertical depth would like land somewhere between your government L2 and your Bell Lake 7 Unit 1, but close to the government L2?
Yeah, I think it's pretty similar on the government L2 and the Bell Lake Unit 1, but I do think the government L2 is most representative of the section that we're talking about.
So if I were to ask you to amend this exhibit to show the I guess to show the equivalent of where the deepest points of those wells exist. What is your thought process there?
I think that would be fair on the like government L2 and the Bell Lake 7-1. But I think again, because it's not a stratigraphic equivalent, it's a TBD. I'm not sure I'd want to take it. I mean, I think it's fine as drawn. But again, I'd kind of focus on the government L2 probably.
Okay, where was the TBD? How was the TBD of the deepest point of those wells derived?
It was derived from looking at the deepest depth through the directional surveys, which I had for all of the Sebastian federal wells.
And would you agree that the TBD listed on that directional survey is the total vertical depth as it relates to the surface location of the well, or in other words, the origin of the directional survey?
That'd be correct for how the survey was taken, yes.
So are you in agreement that the best way to display, even if it's a flat area,
I mean, would you like me to display what I think is the path, the wellbore path of the Sebastian federal wells against the type log of the government L2? Is that what you would be looking for?
I mean, actually maybe that would be the best way to go about it, because I don't think it would be a flat line across here is what I'm trying to get at. I think it's going to be something similar in nature to, the inclination that we have in the formation. Do you see what I'm referring to?
Yes, sir. I mean, if my it's been a little bit since I've looked at this, but I believe it's quite a flat wellbore, and the TBD change over the course of the lateral is quite small.
I guess let me ask you this in a different way. Do you believe that these Sebastian wells are within the same bench across the entirety of their completed lateral?
Yes, I do.
Now, when I'm looking at this cross section, do you think that that's going to be a flat line across that cross section if the well bore is following one of these benches?
Oh, I'd point you to the exhibits from the 210H case. I think that's the same target that is proposed here that was drilled by both the Sebastian Federal Wolfcamp wells. And so I think that would be the most representative of that interval on the type holes that we've shown here.
Okay, could we go ahead?
I do think they stayed within that yellow shaded box. I think they stayed probably within the top 100 feet of that yellow shaded box on the wells.
Ms. Olson, are we looking at Are we looking at the exhibit that Ms. Vance has pulled up right now? Looks like exhibit D3 from case 26296. Is that correct?
Yes, sir. Sorry
Okay.
to jump there. I just think that's kind of showing what you're asking for,
Yeah.
formation.
Oh, yeah, you're perfectly fine with that. Okay, so then so then do you think that depth severance, where would the depth severance land within this cross section? Could you say that one more time?
Yeah, it's the same type walls that are shown in this cross section as the type walls that were shown for the Markham 229 case. So it still would be at that 12,242 feet.
Okay, so
Which should
if
be,
that
go ahead.
if that red dashed line was to be put into this cross section, what would it look like?
It would look the same as it does on the cross section and the exhibits from the 229 case. It would just be on the lower half of that, the very lowest part of that yellow box.
Ms. Vance, can you scroll up just a little bit so I can look at that map of where this is derived? Yeah. So then, Ms. Olson, are these different wells? Is this a different cross section between these two cases? Ms. Vance, could you go back down to one more? I'm sorry.
No,
I
sir,
was just looking at that.
they're the exact same type wells in the cross section from 8A prime in both cases, and they're oriented the same way also.
Okay, well, in your cross section that's in the other case for the east half, you have a line that is depicted, and it's quite literally like where that wolf camp top is. Yeah, like literally right there.
Mm-hmm.
Are you saying that that this is a representation of the depth severance on this cross section?
I do think it's probably a little bit confusing the way that have it annotated there.
Would you agree that if this was a depiction of it, that it quite literally cuts right through the middle of your proposed unit in the case 26296?
And 29296 is the 229.
That's the
case.
upper wolf camp portion.
Can you rephrase your question there?
Yeah, Ms.
Please?
Vance, can we go back to the other case that shows the upper wolf camp? Okay, Ms. Olson, would you, I mean, I don't know if it's relevant for me to get you to say the depth seven goes across, because clearly it's not depicted correctly in the other one. So let me try to figure out what the correct depiction is. Is it correct to think that the depth severance would be towards the bottom of that yellow area across this cross section?
That's correct.
Okay, so would it be accurate to show a dashed line which is not flat, but is going to change within these different wells?
Yeah, I mean there's just with the thickness change, I would probably draw it a little bit lower on the Madeira Ridge 24A or 24-1 on the A side of the cross section. But
And
again, go ahead.
Would you agree that that is in agreement with the depth severance being 100 foot below the depth of the deepest point of those drilled wells?
I mean, if I was picking it for like a stratigraphic equivalent, yes, that would be how you would correlate it. It's just not a stratigraphic equivalent, and so that's why it's drilled at. That's why the dotted line is dashed at that same 12,242 feet and not correlated the way that the Wolfcamp A top is, or the shaded boxes are.
Okay, look, do you agree that the total vertical depth depicted in each of these cross sections is based upon the elevation of wherever those wells are located?
Yes.
As such, if these cross sections are not flattened on like a formation top or something like that, would you agree that it may be flat underground, but not be depicted flat within the cross section?
I mean, I think the cross section is telling you the opposite of that. If I'm understanding your question correctly.
Well, do you know what I guess what do you know what this cross section is flattened on? Is it just from the surface of the ground of the?
Yes, it's not flattened on any formation top. It's a structural cross section.
Okay, and without flattening it, well, okay, let me back up. With the thought that, I mean, okay. I was going to say, I don't know if we need to bring Mr. Johns back, but my interpretation of what Mr. Johns said is that the depth severance is located 100 feet below the deepest point of the drilled wells. Is that also your understanding, Ms. Olson?
That's my understanding, yes, sir.
And do you believe that that total vertical depth would apply based upon, I guess, if there's a hill there, do you think that total vertical depth is based upon, trying to see how to approach this. I think the best way may be for Matador to review the area and try to figure out where the depth severance is, because the depth severance should be depicted upon this cross section as well. And if you were to take it off the last cross section, it's quite literally going to chop right through the middle of your target there. Are you in agreement with that, Ms. Olson?
Yeah, I think can I try phrasing using this cross section what I think you're getting at? I think it's pretty easy to see the depth severance being pretty equivalent to the stratigraphic equivalents, even though that's not what the depth severance is based on the government L2 and Bell Lake 1. I think if you were to drill the same targets on the Madera Ridge 24, they would in fact be lower, but that wasn't the type well that was where these wells were drilled. So like this type well is showing you like how that formation changes from A to A prime, but it's not showing you what's representative of the lease. So I think maybe that's part of the confusion here, is that the TBD drilled for the same target on the Madera Ridge 24 lease would not be the same TBD as it is on the government L2 lease, which is what we're talking about here. Does that help your understanding?
Yes, Ms. Olson. I mean, I think we're getting there, I guess. If I were to ask you, or for Matador at least, to amend these exhibit packets to try to show where that depth severance occurs across this entire depth, where it would occur across this cross section, I guess. Do you understand what I'm asking for?
I think I could represent in this cross section where those wells would be drilled on this cross section, but again, it's not a stratigraphic equivalent depth severance, and so that would just be what the depth severance would be of a proposed well on that section, but not necessarily what's in reality. Is, I mean, I can draw an arrow of the formation that was targeted with each of these well bores, if that would help
Well, perhaps what might be the easiest is if I were to ask for like a gun barrel diagram that is going to show us where each of your proposed wells are going to be placed. And then on that gun barrel diagram, depict for the division where the depth severance occurs. Would that, do you understand what I'm asking for there?
Yes, sir. I could absolutely get that for you.
Okay. And that may actually be the easiest rather than worrying about the cross section. In regards to that, if I were to ask you then to remove this where you have like the depth severance depicted in your exhibit D3 case, if I were to ask you to remove that from the cross section, you understand what I'm asking for?
Yes, sir.
And then Ms. Vance looks like she's showing us the bone spring case. If we could do something similar in this bone spring case where we provide a gun barrel diagram with the depth severance on that instead, do you understand what I'm asking for?
Yes, sir.
Okay. Now, to the far easier and more in your wheelhouse, I guess. On the, Ms. Vance, if we could go back to one of the wolf camp. On this cross section, Ms. Olson, where would the base of the wolf camp A be? The base of the wolf camp A be located? Might be the way to say it.
It would be right above the top of that yellow shaded box.
Okay, and then in the other wolf camp case, if we go there, Ms. Vance.
It would be below where that yellow shaded box is.
Okay, thank you, Ms. Olson. And if I were to ask you to draw the base of the wolf camp A across this cross section, you'd understand what I'd be asking for?
Yes, sir.
Okay, thank you, Ms. Olson. Yeah, so Ms. Olson, would it be accurate to say that your case 26297 is targeting the wolf camp B?
Yes, sir. That's correct.
Thank you, Ms. Olson. Mr. Hearing Examiner, I believe that concludes my questions unless something comes up from Ms. Vance crossing or anything.
No, I don't have any cross, but two things. One, I just want to walk through all of the changes we're going to make so we're on the same page. And we would like to go ahead and continue these cases since it's a lot of changes. And we'd like to make sure we've got plenty of time and